What's up, everybody? Welcome in. The evidence is done. Closing arguments are done. The jury is out and deliberating, and they have Sarah Boone's fate in their hands officially. They will deliberate until 10 o'clock tonight. It's just past 7:15 right now, and today seemed like a long one, a long day. And I said it on Twitter. I don't know if I'm in a mood, but these were not my favorite closing arguments, especially the last two. We're going to get into all three closing arguments: first close, defense close, and rebuttal close. We're also going to talk about the text messages that the prosecution read at the end of the day that I found pretty effective and interesting to be used by both sides. So I'm going to answer your questions. We're going to get into closing arguments. We're going to talk about the whole thing, but let's remember, most cases research shows are not won or lost in closing arguments. So I'm going to start here with running through a few of the text messages that were read at the very end of the case. One, you tell your son he's not welcome here, taken off the lease and bound, worthless. Don't show his ugly effed up face around here again. Police will be called. Ask him if it was worth it. And riding my bike he has. Stay Hispanic. That's what you all are. Disgusting, despicable, and vile. Some of these texts that Sarah Boone sent to George. There were a couple I thought the defense could use, where in these text messages, and again, these are things Sarah Boone did not think was going to come out, wasn't necessarily planned or documented that she was going to use against him in the future. Let them know you beat your wife. If I talked to guys the way you talk to girls, basically, I'd be beaten to a bloody pulp. Those, to me, indicate there's legitimacy to the abuse coming her way. And I think during the closing arguments, the state basically agreed. George isn't the perfect victim. He's not the best guy. He might not even be a good guy. But he did not deserve this. So we're going to jump in, starting with, I'll talk about jury instructions real quick. They are going to go second degree M. They're also going to include manslaughter as a lesser included and culpable negligence. The state didn't want culpable negligence. They said there was no evidence it was negligence because she said it was on purpose, but they presented the evidence of it was unintentional. And so the judge had to leave it in. I would be very surprised if it was culpable negligence, which is technically a misdemeanor, which is up to a year in jail. I mean, that would be a home run win if that's what she ended up getting convicted of for the defense. But yeah, I thought some of the interesting jury instructions, like you have to exhaust every reasonable means to escape the danger other than deadly force. It's like, put a fork in her, she's done. That would have been half of my closing argument, stuck on all of the other things she could have done. And I didn't think anybody really went into that deep enough, but we're going to start with the first close. The state's first close was Cacciatore, who seemed like kind of second chair of the trial to Mr. J. I thought this was the best close of the three. I thought Mr. Cacciatore had some pop to his close, had some theatrics, not too much, not over the top, but enough. And it was the only one that felt timely to me. I was like, okay, good. I see where he's going. There's a beginning, there's a middle, there's an end. And a lot of these closings, I'm going to summarize. We'll play a few clips like we usually do, but not a ton to play through because I don't want to watch them again, if I'm being honest. I don't think they were the greatest presentations we've seen in these cases. And I don't think it was the greatest presentations that these lawyers have done or have in them, which should tell you it has been a very long 2 weeks and a very long day. And there is a stamina to this that you need. I frankly would have preferred to push it to Monday and do the closing on Monday when I'm fresh. But it seems like everybody wants this thing done tonight. I'm also shocked. 7:15, the jury starts basically. And they're going to deliberate till 10. So everybody's kind of expecting a verdict by 10. That's pretty quick. People, stop with the RIP Joe Rogan. Stop with it. Stop with it. I know it's not real. This has happened before with him. Unless it actually is real this time, which would be really a boy crying wolf type of thing. So he puts the suitcase on the ground and he says, this is where he died. In this small box. Very sad. It was a very good visual. He couldn't commit or attempt to commit any crime zipped up in that suitcase. I also really like that. He can't hurt her if he is zipped up in that suitcase. And then sometimes it's a risk to look at all of the jury instructions and pull them out and go that route. Hold on a second. I'm going to pull up a clip here. It's always harder for me when the clip is still active. By the way, if a verdict comes in, we will be live streaming it here. So it's always a risk to me when they go through the jury instructions in closing. A lot of times I'll have a bunch in and then I'll take them out because it's so boring and I'll only keep some of them in. I'll summarize some of them. But from my perspective, I thought he actually did a really good job. A really good job weaving in and using the facts with the jury instructions. Sometimes it can get really boring. Please, guys, please don't spam the chat with "we have a verdict" and all that stuff unless we actually do. Please don't ruin the video. Don't ruin the night, okay? We've been waiting. It's taken forever to get to here. Let's get through these closings. If there's a real verdict, then yes, we will jump to it and listen. I am positive there's not a verdict right now. Okay, so let's hear him discuss weaving some of these jury instructions in to what is second-degree murder, what is manslaughter, what is culpable negligence, what is a depraved mind, how does it work, and how do the facts of this case fit?
Second, when the killing occurs by accident or misfortune, was confined to this box. Next, when the killing is committed by accident and misfortune.
So this is like justifiable homicide. I think it's coming next.
Decides, and it's going to get a little extra real for George Torres. It is not used. The killing is not done in a cruel and unusual manner. This fails on 2 counts. There was no sudden combat. Her words, this was laughing and joking, and we're all having fun. But she decides, and it's going to get a little extra real for George Torres. And it fails on the 2nd count because George Torres was killed in a cruel and unusual manner. Next, we turn to our main charge, second-degree murder.
Here we go. And it's really important for the state to be the one to differentiate and explain why is this the right charge. I don't know that I agree with him, but it's his job to prove to the jury that this is the right charge.
The law informs us that to prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of second-degree murder.
Yeah, the sound cut out, but it comes back. Just in time.
As to the first fact, that George Torres is dead, well, we have stipulation, amongst other things, that agrees to that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3.
Now, and again, I'm big on presentation. Like, it's really important to me. I think a lot about it. I try to make it smooth and really make it sense and catchy and things the jury will remember. Zipping him in versus zipping him out. Not the best, play on words or word usage, but he got his point across, right? She zipped him in. She made the decision to zip him up and zip him in. And she could have made the same decision to unzip him. And she decided not to.
There was an unlawful killing of George Torres by an act imminently dangerous to another in demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is. And it's going to tell us that an act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another in demonstrating a depraved mind if it is an act or a series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself displays an indifference to human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you. IMG 1062.
So what did we say? How do you get to second degree? How did the state get to second degree even charging this? As it feels like a manslaughter case, maybe even involuntary manslaughter, right? But how did they get to second degree? How did they get to that top charge? Did they overcharge them? How are they going to prove it? And so many of you, and we talked about it on this channel so much, really the best way to prove it is the videos from Sarah Boone's own phone. So what does he say? He reads what a depraved heart is. He reads what it takes to get to second degree. And he says, if you had a doubt at all, take one more listen to this. And he plays the video.
States 17.
For everything you've done to me. For everything you've done to me. Fuck you. Fuck you. Stupid. That's my name. Don't wear it on.
I can't fucking believe it. Seriously.
Yeah, that's when you do me, show me.
There's an objection. Sidebar. We're going to skip through it. Just wait till we get to the defense's closing if you really want to talk about objections, which we will.
I can't believe it.
That's on you. Because I got this.
Sarah.
Real ransom. Now you want to give it for it extra. Because I got this.
Sarah.
Real ransom.
I can't believe it.
Oh. That's what I feel like when you jingle me.
Sarah.
Fuck you.
Fucking believe Sarah.
Yeah. You should probably shut the fuck up.
Sarah.
Brianna said, is that enough for malice or ill will? The curse words. Well, Brianna, that's a question for the jury. And that's a question I'm going to ask all of you after we get through these closings on how you would vote. Octavius, your thoughts on O.J. Simpson. So I can't do that in the middle of another, when I'm breaking down another trial, but we are looking into doing a video on this. Owen's theatrics feel a bit forced, just a defense attorney's duty. Dare I speculate? She's been mad at him the last 2 evenings. Has that happened? Most defense attorneys are not going to change their style or do something like that because they feel like their client is mad at them. I think it's kind of just his style. We'll talk about it. I'm going to have some thoughts on this as we go through. Daybreak. In a high-profile case, do you sometimes feel like closings are more about for the public, news, documentary, docudrama, et cetera, than the jury? I sure hope not. I think sometimes it can be a tinge of this, but I really hope not because there's way too much at stake. Justice for victims, justice for the defendants, a just process throughout for America. That's tough. All right. Then he goes, this wasn't the first time she considered it. And this was probably the part I liked least about his closing. And this is when he reads the, I'll get rid of him. I think personally, and I know a lot of you guys are going to disagree with me. I think it's a bit of a stretch to say that a month earlier, when she says, I'll get rid of him after they've broken up a million times, she's kicked him out, she's taken him off the lease. The I get rid of him or I'll get rid of him to mean she's going to end his life and that she's been planning and plotting this for a month. Personally, I think that's a stretch. That's just my opinion. But that's what he went with, that she's been planning this. Isn't the first time she thought about it. Then another very important use of the jury instructions. And you guys let me know this, right? Because this was probably the most asked question. Can intoxication be a defense for Sarah Boone? Because she was drunk. She didn't know what she was doing. Well, I explained it to you guys and the judge explained it in jury instructions, and Cacciatore spelled it out perfectly, just reading what the judge told you. Voluntary intoxication is not a defense for Sarah Boone. You will not hear them get up and make that defense. So I think that was a very good argument. State has the burden to prove beyond a reasonable doubt she was not justified in using deadly force. He says, so this was a part I thought the defense could have done better on close responding to, but he showed all the pictures of Sarah Boone being injured. He says the defense will show you all these photos, talk about what a bad guy and a bad boyfriend George is, but she isn't, and here's this what I like, she isn't entitled to justifiable use. It's not an ace that she has in her pocket. It's not something she can use anytime she wants. It matters at the time, not prior. Very, very important. A reasonably cautious and prudent person under the same circumstances must think the forced use was necessary. And Sarah Boone was the aggressor. He talks about Boone didn't ever withdraw. He starts talking about battered spouse, and he says just because George Torres may have done some bad things, just because he's been arrested, just because he's got a temporary restraining order, doesn't give her an ace in her pocket to kill him whenever she wants to or punish him whenever she wants to. And then he gets into the imminent threat. And we're going to play this because this is where it's supposed to come out, right? The imminent threat is supposed to come out through a lawyer making an argument, not through an expert.
As to whether or not she suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brandon was talking about. Other possibilities have to be ruled out as the trigger for.
I also I don't think he said, and I hope he didn't say it because it helps your appellate argument if you don't hammer home something that was improper. And I don't think he says, even Dr. Warner or Warren, whatever her name was, the state expert, said she was not in imminent fear. I don't think he said it like that. I think he made it his argument, which is the appropriate way to do it.
Or a behavior, or an event. So in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on meant that the trigger was not domestic violence or some.
See, that's not exactly what she said. That would have been a better psychiatric opinion, that the trigger was not domestic violence at that time. But that's not what she said. She said she was not in fear of imminent danger at the time, which is a fact question, not a diagnosis or connecting scientific dots. So I like the way he did it better than her.
Correct. In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's a reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, well, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat.
I mean, this might have been my whole closing. Let's talk about the threat, members of the jury. Let's talk about this threat. Because that's the only way she wins in any kind of self-defense situation, battered spouse or otherwise. She had to be in fear of she had to reasonably be in fear of serious bodily harm or death. 2 fingers, a hand. When she's got a baseball bat, a phone to call 911, she can run, she can film him. He doesn't act up when he's being filmed, the defense said, which they hadn't said at this point, but I think she's really regretting it, Marie. It's pretty bad. Pretty bad.
And we know there was no threat because George Torres never got out of that box. He was never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
So then now he's going to play the second video, and he says, like, you can hear the air is, the witness talked about how every time he took a breath, there was less oxygen in there. He was slowly suffocating. I thought that was really good. He could not commit a crime at that point. Then he reads and uses the credibility instruction that we talk about basically in every case, the witness credibility. And it almost seems like it was written to read and hammer a witness like Sarah Boone. And that's exactly what he did. She is biased. She has an interest in the outcome. She admits lying. She has inconsistent testimony. Her testimony doesn't line up with so much of the other evidence and isn't corroborated by it. It doesn't make logical sense. I mean, it was almost as if it was written to hammer somebody like Sarah Boone's credibility on the stand, which is why it's so dangerous to take the stand and say you lie. And you can't just say, I don't trust cops, that's why I lie to them. That's not just a catch-all. I didn't love his climax, which is like, do you have any doubt about X? Do you have any doubt about Y? Do you have any doubt about Z? I didn't think it was that great. But overall, I thought this was an incredibly effective first close. I think it gave every juror, as many of you are commenting, that was on the state's side, because at this point, most jurors, research would show, have already made up their mind, and he gave them things to go back there and argue for the state, argue for the prosecution. He gave them what they needed to go back there and fight hard for guilty. I think he did exactly that, which is your job during first close. Then we get to some more drama when Mr. Owen stands up and has a problem that he needs to discuss with the judge. And let's watch and then we'll talk about it.
Boone's entitled to a fair trial. I think.
Okay, may proceed.
Sarah Boone's entitled to a fair trial. I think that right's been compromised here today. I don't know who scheduled the two detectives on the front row with the Torres family, the family of the victim, but they had to have known to tell them that the suitcase video, which has been around for 4.5 years, was going to be played during opening statement, and the state attorney's office.
He meant closing argument, but what he's saying is she isn't getting a fair trial because the Torres family and cops are sitting on the front row, and they all should have known that video was going to be played. They should not have been surprised. And here's what he's mad about.
Years was going to be played during opening statement, and the state attorney's office or the sheriff's department had to advise them, or the victim's advocate had to advise them that if they couldn't take it in front of a jury that's trying to decide the case, they needed to get out of the courtroom. Now, what happened here today should not ever happen. There should be safeguards in place. There's no room for this after 2 weeks of a murder trial for something like that to happen. One of the Torres members of the family audibly, during the 2-minute suitcase video, expressed some kind of emotional reaction. I look back, he or she were bent over in agony, physical pain. The physical pain followed the audible announcement. You can't unring that bell. That's their responsibility to ensure that kind of thing doesn't happen, especially when they know they're going to show a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
He responds, it's denied quickly. So here's what I'll say. Number one, I agree with the sentiment that should never happen. We have to be prepared for that. That can absolutely have an effect on a jury. I had multiple people message me and email me being like, that would have an effect on me. Totally unfair, should not happen. Okay? But that was way overboard. Way overboard. I think it was a bit insensitive because regardless of whose fault it is, they've lost a family member. And I just think that you should not. I think you can say, Judge, it's unfortunate that happened. It really shouldn't happen in front of a jury. I think the jury's been poisoned at this point. We can't unring that bell. I move for a mistrial because this is no longer a fair trial to Sarah Boone. And then sit down. Don't try to kick him out of the courtroom. Don't tell him anything like this. Okay? I really think that his argument was right. You're allowed to make that argument, but the way he did it just opened it up for criticism that people are going to lose the message through the delivery, if you get what I'm saying. Losing the message through the delivery is not what you want as a lawyer. You're supposed to be good at the delivery. So again, I agree that should not happen, but not great. Okay, so I was going to play like the beginning of Owen's close. The state objected maybe like 20 times. And at one point, he literally, I don't know if I have it. It's 8:55. And I want to show you guys this because it's pretty funny. I don't know where it is. All right, never mind. Not going to be able to show it to you. He literally is like holding his glasses and he's like, and like looks like he's like saying a prayer. Can they please stop objecting? So let me tell you, I didn't know this at the time while I was watching it, but I was like, this is so incredibly annoying that the state is objecting this much during his closing. They were wrong. You're not allowed to talk about yourself and like use yourself as an example, but all he was saying was, I'm from a small town. You guys are really nice here. That's all he was saying. That's totally appropriate, totally fine. The state probably objected no less than 20 times, and I think they won 1 or 2 of them. They lost almost every single one because defense attorneys and prosecutors are given so much room to argue in closing. And some of the stuff they were objecting is just totally wrong. At one point, they objected 20 times is hyperbolic, is rather hyperbolic. I literally think it was 20 times. I'll have to go back and check. I'll have to go back and check because I don't know exactly how many it was, but it felt like 20 times to me. I'll just say, and I'll just tell you, if you object once or twice during closing, that's a lot. That's a lot. And I personally think they objected way too much. They objected at one point to him reading anything that wasn't in evidence. It's like, if I want to read from my notes, I'll read from my notes. If I want to read from my phone, I'll read from my phone. If I want to read from my PowerPoint, I'll read from my PowerPoint. If I want to read from the dictionary, I'll read from the dictionary. Because you're allowed to read things that aren't in evidence in closing. A poem. We had the state quoting Star Wars, and we're going to get there, okay? So I thought it was so annoying that the state objected over and over and over again, and they lost most of them, and just that's just not good. They shouldn't do that, okay? 17 times were counted. That's pretty close to 20. It's pretty close to 20. Anyways, okay? So now that we've gotten that out of the way with the objections, and if you guys have any more questions about that, we can answer it. Let's talk about his closing. I think this was a closing argument that was literally all over the place. I use the word literally a lot, I guess. He didn't know where his notes were. He had all these individual pages of notes. He was walking the counsel table. He was shuffling. He would say things like, I want to read this exactly because this is really, really important and I want to get it right. And he couldn't find it. So he's like, something to the effect of whatever. And it's like, well, you just told us this was how important this was that you wanted to quote him. And then he couldn't find it. He would start talking about one thing and then he'd say, well, I'm going to get back to the case now. He would give all these analogies like a law enforcement officer who has a weapon pulled on him and he's got to make the decision if he's going to go home to his family. And it's like, sir, that is not what we have here. You're about to say sticking your little fingers out of a suitcase, put her in fear for her life. You cannot give an example of somebody pulling a weapon on a law enforcement officer. And you guys know, and again, I try to shoot it as straight as possible, right? I've liked some things that he said. I don't like some things that he said. The state, I think they did some things good, some things not as good. But this was just so all over the place. It was so hard to follow. Some good points, George has some good days, but he becomes a monster when he's drunk. PTSD is a mental disorder. Dr. Harper said she has it. You're not in your right mind. I would have said something like, they downplayed all those photos about Sarah Boone because they are objective evidence to prove PTSD, battered spouse syndrome. Nobody disputes the facts about what happened that night. But why? Why? Because those pictures prove George was the abuser. That's what I would have argued, something like that. They can't twist the words or clip the videos or read you just some text messages and not others with those pictures. And that's why they want to belittle those pictures. Something like that is what I would have argued. I would have focused on. I think the defense is best evidence. And I think my entire closing argument would have been on the pictures, getting arrested, George getting arrested, the no contact orders, and, the parts of Sarah Boone's story about how she was afraid. That would have been the entirety of my closing. Because the police report, the pictures, and the no contact orders, you can say, judge ordered it. Cops made the determination to arrest him. These pictures you can't fake. I know people are going to say you can fake them, but that's probably what I would have done. Would it have worked? I have no idea. Probably not. I see a lot of people saying they're coming from Emily Baker's stream. What's up? Oh, I can't imagine Emily liked any of these closing, or the second two closings. I can't imagine that. I put Cacciatore was way better in my opinion. These are just kind of my notes as I'm listening. I was like, not my favorite. He admits Sarah talked down to George, was mean to George, would say abusive things, but she's not charged with that. I was like, I wouldn't have admitted that. Someone can be mean, hateful, and intoxicated and still be abused. Okay. That could work both ways. All right. I don't know if I even want to play this. We'll play a little bit of it.
In your face, whatever she does, you do not have a right to hit a straight. You grab him by the neck and try to get him out the ball. So yeah, you're committing an act, but it's designed to defend another, which is illegal. Or let's say you have a situation where you have a police officer and he's on patrol. He's in uniform, he's wearing a firearm, and of course he's got the bulletproof vest. And he's called. Mr. Henderson said, "Did that surprise you?" The box for the state.
Oh, here we go. This is where he talks about the first witness in the box for the state was good for us.
If you remember, it was Juan Torres, the brother. Remember that? It was some time ago. Now it's been a while. Y'all taking notes. You may have to go back. Their first witness was a good witness for us. Their first witness in their prosecution of Sarah Boone for murder was a good witness for us. Remember Tony Henderson with the cross-examiner, Juan Torres. Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, "He's been choking me. He's been choking me." Mr. Henderson said, "Did that surprise you?" Juan Torres said, "No." That family knew what was going on. The police knew what was going on. The neighbors knew what was going on. Pearl Walker came in here. You do not put your hands on a girl.
Here we go. Here was another argument that he had, okay? You don't put your hands on a girl. That's what he says. And I know people hate when men use the word girl. I have done it before. And I don't mean anything demeaning by it. I understand people get mad about it. And I think this is going to rub some of the ladies on the jury the wrong way. I also think that it's correct, right? You never hit a lady. A lady should never hit a man, right? A woman should never hit a man, whatever. But it's like if a woman is killing you or suffocating you or has you trapped in a suitcase, it's like, I think you're allowed to stick your hand out of it and try to get out of it. And I think you're allowed to be mad at the person putting you in there. I thought, I was like, you know what happened here, man? Like, this was a very weird, it was very clear that he was trying to go battered woman syndrome, trying to explain that George Torres, even though they're the same size, was physically could outmatch her every day of the week. I just thought it was a very detached delivery. I don't know what it was. You guys let me know if you agree or disagree in the chat.
You can't wrestle with them. You can't punch them. You can't kick them. You can't treat women that way. When you become adults, I don't care what she does to you. I don't care what she says to you. If she gets in your face, whatever she does, you do not have a right to hit a woman. No, sir.
And by the way, I 100% agree with that. I'm not saying I don't agree with that, right? I'm not saying you can put your hands on a woman, or if she does something, you can do that. I'm not saying that one bit. But in this situation, if she has him locked in a suitcase and we got to remember what the overt act is, sticking his fingers or hand out of that suitcase. Is that the same thing as hitting a woman? He's not on trial for battery of Sarah Boone. George Torres is not on trial for domestic violence here.
What has the state attorney tried to do?
Objection. Argument. Sustained.
What has they done?
Objection.
What evidence have they tried to put on?
Overruled.
What evidence have they tried to paint Sarah's? What evidence? Control and manipulated were the words they used.
Oh, by the way, I forgot to mention that, and we're going to listen to him respond to it here, but Cacciatore's like, is it possible George Torres is the battered spouse? And while that gives the defense the door open to do something like this, you had to say it because so many people are thinking it. And the jurors that are with you are going to be like, yup. So it's worth the risk to give the defense fodder for their closing argument, which I think that's what's coming next, and Owens will listen to a little bit more.
Yeah, this ain't the 1900s. This is 2024. What's all these text messages? Why is that relevant? What are they trying to claim?
I think it's clear what they're trying to claim with those, right?
She provoked his violence. She provoked his violence. Isn't that what they've done here in this trial?
Argument. Sustained.
So he's trying to argue the she deserved it or victim blaming. That's what he's trying to argue here that they're doing to Sarah Boone.
Let me get back on this. Abraham, you got to take either.
Sidebar here.
We got here. Vincent, the tag, putting me down. Of course, I had time to talk by then.
All right, forget it. I'll just summarize it. I don't know where the part is about Dr. Warner, but he says she has the battered spouse. Even Dr. Warner said she has battered spouse syndrome. The state attorneys said whatever about these photos. They say maybe George Torres is the battered spouse. How horrible is that? Oh, actually, that was right before the don't hit a girl part. And then he talked about how Marino changed his statement, how the state objects, or not that the state objects to everything. This is just the state is always objecting to everything. And he is, George Torres is a grown man. He decided to get in the suitcase himself. She likes to videotape a lot. Okay. And he gets into Sarah Boone videotaping things. She likes to videotape a lot. That's where she has some control. Words are her weapon of choice. That's even what their expert said. She was thinking, this is my chance. I was like, I don't know, man. I don't know if I was being overly sensitive, but none of those I felt like were helpful to the defense. And then he says, can you imagine, or you can imagine, objection to the golden rule? It was not a golden rule objection at all. And yet they still objected. Like, it was the opposite of, let's try not to object during closing. They objected a million times. And frankly, I think that's going to be something that comes up in appeal. They objected that many times. Especially when it wasn't going well. So why would you want to take the chance that the jury thinks you're a jerk because you're objecting so much? Right? I wouldn't even want to take that chance. All right, let's try to find this part, because this is the imminent, this is how he explains the imminent harm.
That's an imminent threat. Just by a couple of things, the way he just says it, right? The way of talking to people. We've got.
All right, here we go. So this is his explanation of basically the most important part of the case for them to get self-defense. What was the imminent threat of serious bodily harm or death?
The way your wife, your husband, you know each other. You know, when they come in from work, what kind of mood they're in. Just by a couple of things, the way you just sense it, right? Well, especially somebody as hypervigilant as Sarah, and as hypervigilant as a battered spouse woman would realize that he can flip the switch at any time. When I get out of here, I'm going to end you. And he realizes he's getting out. He got his hand out. At that moment in time, in Sarah's mind, that's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in, remember? She tried to get his hand to go back in. When he go back in, so her son's back was 3 feet away. When the police found it, the next morning, same spot. No attempts to hide, no attempts to delete phone, no attempts to tamper with evidence, nothing. In the same spot as what? She picks up the bat, she pokes him hard, trying to get him to stop trying to get out. And eventually he does. And you've seen the blunt force injuries, and you saw some of the circular injuries where you can tell there's a poking that gets right around here. And she poked him several times. Remember?
It's wild to say poking that caused blunt force trauma. Think about that. How hard did you have to poke somebody with a baseball bat?
The pathologist said, I think, maybe 5, 6, or 7 times. She pokes him. And he's got some scratches. I don't know if they'll let you look at it, but on the back of that suitcase, it's got some bars, some metal bars that are inside the lining. There's some lining. And it's for support when you walk in. She testified. You heard what she said, that she was justified. That's uncontroverted testimony. Now, let's talk about the jury instructions just for a minute.
That was it. That was his explanation of the overt act that put her in fear of serious bodily harm or death. I honestly didn't get it. I didn't feel it for 1 second. I think it was always a tough argument. I actually think it's hard because she obviously didn't want manslaughter. She didn't want a lesser included. She didn't want a deal like that. But the more I watch this trial, it could have been a win to get something like that. I guess not really a win if the state was even going to offer it. It's just, this is a very strange case, a very strange case. I'm going to jump ahead a little bit to him explaining how certain things were intentional that she did.
Somebody quotes it. She would often flee to her ex-husband's house. I believe that testimony came out from Sarah or somebody. That sometimes she would flee, or sometimes she would flee to upstairs. One of those two. But the dogs were up there. She made a phone call. At some point, she fell asleep, passed out, fell asleep. We don't know. They had 2 big bottles of wine, right? That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation room? You remember that? Now, I don't know if we did a good job of this, but it came out that she got arrested. You remember the one time when she got the black eye? She got arrested for strangulation. And you remember that? It was standing up over there by the dryer, and he was banging her back of her head on the floor that had some very little carpet on it. And she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her. And that's when he got up and stomped her in the eye. Remember? Well, the police came for that event, and they took statement, and Sarah was honest with the officers about what all, and they arrested her. You remember? Remember that? They arrested her. And she said, why? I was fighting back. You remember that? Why? I was fighting back. So from that point on, she didn't trust law enforcement. The video that they showed a while ago about George, that was about dropping the case, where she was defending herself and fighting back. I want to talk about this investigation by law enforcement. Now,
so that was basically his explanation as to why Sarah lied. And then, of course, he shows the picture. He shows a video where George kind of slaps the phone out of Sarah's hand and looks like he's slapping her around a little bit maybe, and says, a switch flips. He goes from being nice to, abusing her basically. And it was right after he said, he's a good boy when she turns on the phone or something to that effect. And then we get to the rebuttal. Okay, Mr. J. And he made some good points. She uses the judicial system as a weapon. I agree with that. I think throughout the entirety of this trial, he and I don't have the same like analogies or stories, because when he uses certain analogies or tells certain stories, I'm like, I just don't see that as applicable here. I don't see that as what we're dealing with here. And when he went into Star Wars, I knew where he was going. And again, I just didn't think it applied. Okay. You guys tell me if you liked it, the Star Wars analogy. But the Force and how it works is they actually do it, control it, contain it, stop, start. It's intentional. You don't accidentally use the Force, right? And it's not something that they do and they just leave over there. And it's not something that they set up and then leave there for it to happen after they leave. And so I just didn't see the Force as the same thing that Sarah Boone did in this case. To me, it's more like burying someone and walking away and acting like you didn't do it and you didn't bury them. And when they die, you act surprised. You know, I would have used things like that that were just so obviously like this and so obviously horrible that they can't help but connect it to this case. And to me, a lot of them just kind of missed. And I thought his second close felt so long because there was so much repetition to what we already heard in Cacciatore's first close. And so every time I heard the same thing, I was like, okay, he already said that. He already said that. He already said that. I think at some point he said he was treated like a dog, maybe a dog that bit in the past, something to that effect. And I was like, oof, didn't love that either. Didn't love that either. He makes fun of their argument, like I said, about, you know, oh, I thought George was good when the phone was turned on. But then he shows a video of George coming at her after he turned the phone on. So, haha, their argument was wrong. I was like, I don't think I would have characterized, you know, George acting wrong on video that was just played in the defense's close. And overall, I felt like, in case you haven't noticed, Owen's close and Mr. J's close dragged on way too long. I thought as quick as the state went through the case, it was organized. It was knock them or set them up, knock them down. I thought that was so good, so well done. And even though Cacciatore, I know some people were saying like when you listen to it faster, Cacciatore sounds better. You're probably right about that. But at least he was prepared. He was planned. He got through it. Rebuttal can be harder sometimes, right? Because you're taking notes. You're trying to respond to what the defense does. What I like to do in rebuttal, just like in cross-examination, I like to do it a hybrid. I prepare certain things, but I also respond to certain things. But you got to have kind of a beginning and an end prepared so it sounds good and it kind of goes well. And then in the middle, you can respond to a bunch of stuff. I just honestly think it wasn't my favorite part of the trial, but it was late for both of these guys. It's been a long 2 weeks. So we always give grace. And I think that they hit a lot of the points and said a lot of the things that needed to be said, whether it was perfect or not. It's easy for me to sit here and Monday morning quarterback it. I'm sure if either of them watched the closing argument that I did, they could have critiques on it too. And I would respect it. I would look at it and I would try to be better the next time around. So I want to make sure I throw all that in there because I don't want to come down hard on anybody. And I think overall, both of these lawyers, you know, all the lawyers involved, I thought had really good moments in this trial, really good moments. I think all of them are good lawyers, experienced. And it just, in my opinion, was not the best closing arguments that we've ever seen. Okay. So now I'm going to go ahead and put it on the end. So we're not missing anything and we are live. I'm going to make it smaller and I'm going to answer your questions. Hi, don't you think she could have lied in her texts? She's a proven liar. She knew other people were reading them. What if he was defending himself? Of course she could lie. Somebody else said, so I said on Twitter, I think, the state presented evidence that this was unintentional. They presented Sarah Boone's statements that this was unintentional. Okay. And somebody was like, well, she was obviously lying. It's like, okay, but that's not how evidence works and testimony works. If somebody presents evidence or presents testimony, the jury can consider it as facts, and you have to apply the jury instructions and the verdicts to those facts. Whether somebody's lying or not is a decision for the jury. But those were facts that were presented. Diva Dawn, assuming a hypothetical hung jury, would the state try again considering 5 years and how expensive? Saw a comment earlier, Owens won't do a second. I think the state, I don't think it was that difficult of a trial for the state, if I'm being honest. I don't think it was that expensive of a trial. I think the most expensive part of this trial was Sarah Boone's defense. Okay. Kelsey just reminded me. Now that we're done with the evidence, we're done with closings, we're going to put up a poll. And the poll is, what is your verdict right now? After all the evidence, after all the closing arguments, I'm going to give you 4 options. Guilty of second degree, guilty of manslaughter, guilty of culpable negligence, or not guilty. Okay? And the guilty of second degree is depraved heart intended to end his life. Manslaughter is the intentional killing of another person in the heat of passion in response to an adequate provocation, doing so even through culpable negligence or some other act that intended to end somebody's life. Involuntary manslaughter is an unintentional killing, which is not a lesser included of second degree and not on the verdict form. Culpable negligence is just basically an accident that leads to injuring somebody that is a first degree misdemeanor. Okay. If we need to dig into those more, I have the, I guess we can play that part if we want to on speed read. All right, we can listen to the judge explain this real quick.
Of which he is charged. There may be evidence the defendant had an intent to cause death, hatred, spite, a depraved mind. 3.
All right, so we're starting with second degree murder and we'll go to the lesser included.
There was an unlawful killing of George Torres by an act.
So go ahead and put up the poll, Kelsey, and we're going to listen to what each of these things are while you guys are voting.
The crime of second degree murder. The state must prove the following 3 elements beyond a reasonable doubt. 1. George Torres is dead. 2. The death was caused by the criminal act of Sarah Boone. 3. There was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or to serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. 3.4, when there are lesser included crimes or attempts. In considering the evidence.
All right, so they intended to do the act that was reasonably likely to cause death. That was, overly reckless, a depraved heart, evil mind, a bunch of different definitions of it. And that's why they used that video. Okay, so that's second degree. And now we're going to get into the lesser included.
You should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is charged, there may be evidence that she committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of second degree murder is manslaughter, culpable negligence. 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, George Torres is dead. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Yes.
So that's kind of the confusing part about having culpable negligence as its own lesser included, because if she ended his life by culpable negligence, then technically it's manslaughter, but culpable negligence includes a personal injury. And so it's kind of confusing how you can do both there. But from my perspective, and I see the votes are already coming in, and the vast majority of people, over 70%, are saying guilty of second degree. It looks like in second place is manslaughter at 20%. Culpable negligence is 6%. Not guilty is only 1% at this point. I think I would kind of be in the manslaughter box because I'm very confident beyond a reasonable doubt that that is the case. The depraved heart, depraved mind, reckless disregard for human life, all of that from my perspective, when you add in the drunk and went upstairs and passed out, not that voluntary intoxication is a defense to that, but what was her intent? What was her ill will? What did she want to happen? From my perspective, I just feel more comfortable with manslaughter. Personally, if I was voting as a juror, it seems like a lot of you guys are still at that second degree charge. And the votes will continue to come in as we listen to him describe culpable negligence.
I apologize. 4. Thank you for that clarification. Sarah Boone, I'll reread those for you. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. Or B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I've previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act. Intentionally committed an act
so we can hear that one more time.
or acts that cause the death of George Torres, or B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I've previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Capable negligence is a course of conduct showing reckless disregard of human life, or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known, or reasonably should have known, was likely to cause death or great bodily injury.
See, I think that's kind of where I would land, is the manslaughter by culpable negligence, that she knew what she was doing should have led to death or serious bodily harm. And I don't think this was justified by battered spouse or self-defense by an overt act that she was in fear of imminent harm. I don't believe that. That's kind of where I would land. Somebody asked a good question here. Where is it? If you were the holdout vote with 5 other jurors being in favor of second degree, could you be convinced to switch your vote, or are you certain enough to hang the jury? Just curious. No, I could be convinced. Yeah, I would have an open mind. I would discuss it with everybody. And I would discuss why people thought second degree. And I think I could get there. I'm between, if anything, second degree and manslaughter. That's where I would be in this case. My take from closing, even if it was mutual, he's the one that's dead and she did it. Situation reversed, what would we all be saying? Yeah. And this is what a lot of people have been commenting. Suber, can you imagine, or can you organize an interview with Owen's content? I mean, I would talk to him. I'm not going to go out of my way to organize. I really am not one to go out of my way to organize interviews. Sometimes people reach out to me, which is cool. And, you know, I'll talk to them. And the problem is, it's like, I want to be fair and I want to ask questions that are interesting and that have to do with the case. And if they don't want to talk about that, that's fine. If he would want to, I'd be fine with that too. That'd be cool to talk to him, I think, and ask him questions about this. Mary Claire, I knew somebody was going to mention this. When he referred to his 2 female defense attorneys as girls, yet introduced the men by name, I want to jump to the screen. I don't know if I've cringed so hard in a long time. I was like, Smokey McDubs. The case has been laid out in its entirety. What do you think the jury will do? And we potentially have the biggest World Series in history. Change anything? It's a good point. I think if I had to guess or bet what the jury's going to do, and you guys have now confirmed by the chat being on the same page, I think the jury's going to come back with second degree murder guilty. I don't think it's going to be a hung jury. I think at the very least, they will convict her of manslaughter. What did they ask the jurors in jury selection? to, or that he seems so confident they won't see a man as DV. I don't know. I did not listen to all of jury selection. If found guilty, can the family go after Boone for any funds paid to her? Sure. But I don't know if there's going to be a lot of funds paid to her. Why did the state never bring up the fact that Sarah turned the suitcase upside down so George had no chance of getting out? They did, but they didn't highlight it. They did talk about how in the 2 videos it was flipped 2 ways, but they really didn't highlight it. Defense introed his female attorney numbers by the girls. And introed the male by their name. Not a good look. I caught it immediately. So did I. And I knew you guys would too. That's different than saying like those girls and these guys. Like girls and guys or guys and gals. Sometimes I struggle with that. So now I try to say women or ladies. I'm learning. We're all growing together, right? I know we talked about the 17 objections, but why did they? Was that a strategy? I don't get it. I don't know. I don't think it was a strategy. I don't think it's a good look. I think he honestly thought that they were objectionable comments and arguments, and it just was a miss. It was a miss, in my opinion. Can Jay's family sue Sarah Boone for wrongful death after this? Yes, they could sue her. I don't think there's much to get. What will the sentence be if she's convicted of a second-degree murder? It could be up to life. I think 22 and a half to life, manslaughter up to 15 years. When Sarah first said she isn't drinking alcohol anymore, when she was with the detective, I said, sure you will. In prison, it's called hooch. Oof. Should have read that one before. I was so disappointed in the defense closing. He spent no time on imminent danger, which was her entire defense. Star Wars analogy I didn't get at all. Yeah, I played you the entire part of his imminent danger argument. It was about 2 minutes long. What if the jury doesn't like Star Wars? I don't know. I don't think it's going to matter. So at the end of the day, I think there was enough done in the closings to connect all the dots to where if a juror was going to vote guilty, the closings did not change their mind. If a juror was on not guilty, I think it's possible that some juror's mind could be changed at least to manslaughter, if not second-degree murder, based on the arguments. Possible. Verdict tonight, if guilty, does the judge decide the penalty? Sentencing at a later date or immediately? I think sentencing will be at a later date. Yes, the judge will decide the sentencing. That's what happens in Florida. My guess is there's going to be a verdict tonight. It seems like everybody wants a verdict tonight. Did I hear right that the defense argued in closing death was unintentional after the entire argument was being intentional self-defense? He definitely argued there were unintentional elements. I know you want to give Owens credit, but can we please draw the line at using blatant misogyny as an argument? I'm not saying I don't want to give anybody, I'm not trying to give people credit just to give people credit. How long of a sentence is she facing at max? Life. How many times have you seen a black eye with no swelling? Look at Owen's huge picture. I looked at it. I saw it. It looked real enough to me. I'm not an expert, though. I will agree with you there. I'm not an expert. Is the jury sitting on the defense's side? Yes, it seemed that way, which is also unusual. I've never had a trial like that. As a civil plaintiff, we usually sit on the juror's side. His rebuttal set a seed in the jurors' minds that they do not have to believe her testimony and gave them a more convincing explanation about how she was killed. Jay swayed it for me. Well, kudos to him. And if he ends up winning, it goes down as a victory and history is written by the victors. So good on him if they win. And they did enough. Without knowing the average age of the jury, I can't help but wonder if Owen's obvious old-fashioned notions were a turnoff to them. I think they were older. I'm not positive, but I also think it was predominantly women that were the ones actually deliberating. So were they offended by any of the girls' comments? I don't know. Were they offended by any of the arguments? I don't know. Somebody asked the comment about how they know that maybe men weren't going to be seen as victims. Maybe that's why he thought. I don't know. Shouldn't it have been Owens with the Star Wars analogy? Ladies and gentlemen of this jury, if Chewbacca lives in Endor, you must acquit. I'm not a big Star Wars nerd, so I don't mean to call them nerds. I mean, Star Wars buff, I should say. I don't know what any of this means. Paul, I have seen them, but I don't have them memorized. I do not believe Sarah Boone was ever in fear for her life. I agree. I don't know about ever. Okay, hold on. I'm not going to say that she was never in fear for her life ever with George. I don't know if I'd go that far, but that night, I don't think she was while he was in the suitcase. The way she spoke to him while taping him as he cowered against the wall truly demonstrated her narcissist need for dominance, not fear. My take was he also wasn't afraid of her. Definitely not physically. GT Ace shirt was worn by a family member. I voted manslaughter on your instructions, intended to cause death, but the judge said intent to cause death not required. Correct. On the judge's instruction, go second-degree murder. Yeah, but you have to intend to commit an act that is reasonably likely to cause death. So there's that element of it. Thank you. I'm still at manslaughter. You didn't watch all of the closing arguments. Jay gave another closing after Owens. I did watch it. I promise you I watched it. I just didn't have time to put more clips into this tonight because I really want to answer all of your questions. Did any of the experts talk about how often DV victims call the cops? The friends I know with that experience never called them out of retaliation or fear. No, I don't think that was brought up in evidence. I mean, judge said second degree intent to cause death is not required, but you said it was on the vote. So I absolutely may have said that because you have to intend to commit an act that is reasonably likely to cause death. You don't have to intend for them to die. Welcome, Robin. Owens is no Mark Eiglarsh interview, just saying. That was a fun one. How in the world do juries keep a poker face? You have to ask them. Do you think they'll come back with second degree? Yes, that's where I think they will come back. Thank you, Chris, for gifting the membership. And Kathy, thank you for gifting 5 memberships. Peter, I remember that video you did like 3 years ago explaining what depraved heart was in relation to this case. So crazy. Thanks for covering. It's wild to think how long we've been talking about this case. Welcome, Jacob. Can't wait for a verdict, but don't mind her squirming all weekend. Oof, yeah, this is the worst time. And I was thinking, if I went on Monday, it's been a couple years since I've sat in a courtroom and watched live a criminal verdict. Because most of my trials over the last 3 or 4 years have all been civil. What did you think of Mr. J's alternate series of events with the suitcase / loud noise? I just didn't find it that effective I don't know. But I didn't find Owens is either that nothing was disturbed at the bottom of the stairs, so she couldn't have pushed him down the stairs. I don't know. That type of stuff I just wouldn't get into the weeds on, that you don't have definitive evidence and you don't need it. I guess it shows she's even worse and it shows more of a depraved heart and mind, but why didn't they call Brian back to talk about the abuse? I am shocked. I thought he would be such a good witness for the state. I'm not surprised the defense didn't call him. My daughter does makeup. She can do a fake black eye. I'm definitely not saying it's impossible. Peter, that is the Wookiee defense from South Park. South Park also not something, South Park I didn't even watch. So I wasn't allowed to watch it as a kid and I never watched it as I got older. Thank you for the super sticker, Jacob. Azam, Peter, general question, potentially dumb. It's not going to be dumb. We saw a defendant used to listen to the sidebars. Is it possible allowed for a non-dangerous defendant to join their attorneys at sidebar? Is there any particular rule for it? You can explain it at the end. Thanks. So you can ask for it. It's a judge by judge thing. Defense strategies are different. They'll let you go back and explain it to your client. Sometimes they'll give headphones. I would not say that it's mandated, but I think most judges would allow it if you pushed for it as a lawyer and your client really wanted to be up there. I would advise my client not to. Just let me come and tell them because it looks weird and I don't want to give off anything to the jury. I also don't want them getting up, walking back and forth because sometimes the way people walk, the way they stand, the way they listen, their facial expressions, a jury's looking at all that and only God knows what can happen at a sidebar. How could the state of Massachusetts change their rules to require polling the jury? Would they have to pass actual legislation or use some kind of case law? How is case law made? Does poll juries? I think again, I'm not an expert on Massachusetts law, but I think they can poll the jury. I think they could have, right? I just think the judge chose not to. Maybe I'm wrong about that. Interest peaked. And to change the law, the legislature needs to change the law. I'm surprised more people didn't vote manslaughter. From Sarah's videos, seems like she was enjoying having him in torment. Malicious but unintentional. Nicole, if she appeals, does she have to pay for it herself, or is there a court appointment for attorney for that? There is a court appointed attorney for that. I would assume that she hasn't waived that right. I think that would be going a bridge too far personally. You've said by close, the jury knows who they believe. Nothing to lose. Let the other side make a fool of themselves. Objecting during close is gross. I agree. Welcome, AVK. Sri, these zealous efforts confirmed how unfair it was for Kranick to force pro se without giving Sarah Boone a clear ultimatum. By the way, best channel on YouTube. Thank you. Thank you. Dewana Montoya, I hope we get a verdict tonight. I mean, selfishly, I'd like it to roll to Monday so I can go watch the verdict, watch and be there live in person for the verdict, but I think we're going to get one tonight. Marilyn, thank you for gifting 5 members. Let's see here. A horse in his beer. Assuming that Owens took this case because he believes everyone deserves a defense and that he maintained all his ethical obligations, do you think he really believed what he was saying today? Yes. I think he did believe it. I even like felt it sometimes when he looked at those pictures. I felt like he felt really bad for Sarah Boone. I think he absolutely believes that George Torres abused Sarah Boone. The only thing that's hard for me to believe is that a couple fingers coming out of the suitcase put her in imminent fear of serious bodily harm, but maybe based on past events, then maybe he believed it. I don't think he would argue something he didn't believe. I would hope not. I have to leave now. Thank you for spending your day with us, Peter, even during your super daddy duty. We appreciate you so much. Yes, that's why I wanted those closings to end so I can come get it done so I can go finish my movie with my kids now. And if we get a verdict, I will do my best to come back here live. Please, everybody hit the like button if you haven't already. I don't think I said that. Like this video, please. It helps out a ton. And please make sure you subscribe to our page. We're rolling up to 500,000 subscribers. I can't believe it. If all of you guys would subscribe, it would help a ton. Octavius, go Dodgers. It's Dodgers and Yankees. Tell me who you got in the chat, Dodgers or Yankees. Welcome Mickey and all the new members from tonight. If there's no verdict tonight, you think it's either manslaughter or second degree? Not that anyone thinks not guilty. I don't know. We'll see. We will see. All right, folks, that's all we got. We will continue to watch and keep track and see if a verdict comes down and try to jump on. A lot of Dodgers, a lot of Yankees. A little mix here, a little mix. Dom said none. All right, that's all we got. Till next time, which might be later on tonight. I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.